Yes, Mr.
My lords, my lady, can I pick up 2 points from this morning and then move forward to my submissions with this encouragement that I've been able over the short adjournment to consider how much more will be needed on all of those headings. And I've all done a lot of reduction. So I'll comfortably finish within the time that I indicated, subject, of course, to what the court would wish me to deal with. 2 points I wish to pick up on are, first of all, legal certainty, and secondly, do I know an authority which we rely upon that shows that our arguments are right. Take them in that order. Could I take you, please, back to Justice Flow in Pan Petroleum, which is bundle 2 of the authorities bundle, tab 22, page 739. And this is back to the point that my Lord Justice Baker put to me about the language of Lord Justice Flow in that judgment.
Yeah.
So page 739. Can I respectfully remind the court that the issue in play were the applicable legal principles of paragraph 41 at the foot of the page in relation to construction of court orders and findings of contempt in relation to breach of an order. That was the issue in play, which was essentially common ground between the parties before the judge and before this court. And then the principles he summarises are threefold. The sole question for the court is what the order means, so that issues as to whether it should have been granted, and if so, in what terms, are not relevant to construction. In considering the meaning of an order, and this is the clause that my Lord had in mind, I know, granting an injunction, the terms in which it was made are to be restrictively construed. Such are the penal consequences of breach. The order must be clear and unequivocal, and strictly construed before a party will be found to have broken the terms of the order, and thus to be in contempt of the court, or kept in contempt of court of the judgment, approving inter alia the statements of and the references. And then thirdly, I needn't read out. My lords, of course, it goes without saying that we do not quarrel with the principle there being enunciated. But what we wish to just most respectfully remind the court of is this, that is not really an issue for now, unless and until you reach the view, which we obviously in our submission respectfully hope you do not, and that we're approaching the unarguability threshold that my learned friend has to clear, or we have to clear for him to or us to survive, call it what John will. The critical point to remember is that the law has baked in, law of contempt has baked in protection for a defendant or respondent, use whichever label is more appropriate, in the sense that at trial, the contempt, where it's a criminal contempt, will not be proved unless intention is proved, and intention cannot be proved unless the purpose is identified. In other words, for us to succeed at trial, we will have to prove the purpose of the provision in the injunction which we say is in play, and we'll have to prove that that was known by VietJet, and VietJet intentionally tried to get round it. I use it as shorthand. But my lords and my lady, for now, that is not an issue that should be concerning this court with respect. We fully take on board the importance of recognising that we have to prove in the end, for example, that the language of the order embraced the concept of export, and that export was prohibited, was one of the provisions that fell within the language that was used by the court.
Sorry, just that again. You will have to show at trial the language of the order
included export. In other words, we'll have to show what our argument was, and I'm noting Mr. Milner's reservation in before the judge, which you pointed out to me. I think my Lord Justice Mills pointed out to me that he recited when.
If the language of the order included export, why is the issue not whether or not there was a breach of the order?
Because it depends upon whether what was done was successful or not.
You're not alleging it was.
Exactly. So if we look, can I take you to the terms of the order? Can we go to Supplementary Bundle tab 8, page 78. And come please on page 79 to clause 1. It is ordered that, until further order of this court, the defendant is prohibited from taking steps to re-register the aircraft with the CAAV, taking possession of or operating the aircraft either directly or indirectly, or otherwise interfering with the claimant's right to possession, custody and or control of the aircraft. Those are the terms which the order are made.
So you've got to show, have you, at trial, that that language incorporates export.
We'll have to show that the prohibition upon interference with the claimant's right to possession, custody or control included a prohibition upon interfering with its right to export the planes. That's what we'll have to do, and then we'll have to show.
But if you do that, why haven't you shown a breach of the order?
Because whether it constitutes an otherwise an interfere, it would only be caught by the language of otherwise interfering with the claimant's right to, and it would be an incomplete attempt in the sense that the letters that we have written to encourage third parties to take steps that may have that consequence is not in and of itself a breach of the order, the view that was taken.
Right, so just to understand the factual context, because it's not being alleged that the letters had an impact, a causal effect of interfering with export, you need to say that there's a criminal contempt in the attempt to do something that, if it had been successful, would have been a breach of the order.
Insofar as my lady's analysis goes, that's right. I put it in that, I hope not discourteous, because we don't know what the effect was. We've never seen what happened next. We don't know what was sent by the Deputy Prime Minister, the Minister of Transport, the CAAV, or the VCA. So we don't know. We've reserved our position expressly as to all that in the papers.
Well, I don't want to lead you off your track, but could it not be said that writing the letters, I'm speaking hypothetically for a moment, could it not be said that it's arguable that writing the letters in May and or the autumn amounted to interfering with the claimants with your right to possession or control of the aircraft?
Well, the mere writing of the letters, we took the view, did not amount to that. It could be said, but we took the view there wouldn't be able to be proved on what we then knew. Well, I understand exactly what my lord is saying, and obviously something we gave thought to at the time. But in our submission, in order for the interference to be made out, we have to have something more than we did have, or do have. But the purpose behind writing them, the clarity of what was prohibited in the order and so forth, is unaffected by that. And so the first thing that we want to just emphasise, please, this afternoon, picking up on the exchange this morning, is that we accept that the burden is upon us to prove both purpose and intent in order to be able to prove at the contempt trial the contempts that we allege in 3A and 3B as they now are numbered. But taking as read at the moment that we are able to satisfy the test of proving those elements, that these are not matters that should stand in the way of our succeeding on this appeal. The second issue that we'd like to just follow up on, please, is the question that my lord put to me about do you have a case you're going to point us to, etc. And it's really just for completeness. I know you've read this already. Can I just take you, please, in our skeleton argument, core bundle, page 48. Our skeleton argument. Paragraph 41. This is as close as we get.
So Michael Burke.
Yes, exactly. Can I just invite you just to briefly remind yourself what we there say, and then I'm going to take you to the report. If I could take you, please, to the Authorities Bundle 2, tab 31, page 866. The factual position in this case was an involved one, and I'm not going to take up a large chunk of my allotted time picking you through the detail of it, but merely to give a more developed answer to your prior question. It is an authority which, I recognizing it is only first instance, with the greatest respect to the learned judge, and recognizing the factual matrix is a complicated one, that I would invite you, please, to note what this is about. So paragraph 107 on page 905. Outlines what this application, which is applications 3 and 4, in the context of the report is about. And you'll see it's the issuing of criminal complaints. And then if you pick it up on the pre-penultimate line of 107, an allegation of contempt by interference with justice though in relation not to victimization after giving evidence, but seeking to prevent the witnesses from giving evidence. And particulars are then given, which I'm not going to take you through now. But if you were to come on to paragraph 121 on page 913, you'll see what his lordship there concluded. If I could invite you just to glance at that, please. So, my lord, that is, it may not be much, but that is as close as we get to an authority that is supportive of our approach, that you can have against an injunction respondent an allegation of criminal contempt.
But there wasn't any. Was there any question of breach of an order?
No.
Right.
Just give me 1 second. Sorry, I'll come back to you on that in just a moment, if I may. Just give me 1 second, please. Can I come on, please, to our second of the 4 headings I wanted to address, which is, what is the purpose of the injunction in this case? The order in question on this appeal was one of several made during the course of proceedings to safeguard FWA's rights pending final resolution of various issues by the court. Its origin is in paragraph 4 of Mr Justice Bryan's consent order of the 16th of November 2022. For your reference, but no need to turn to this stage, is Supplementary Bundle tab 6, page 71, which has established FWA's entitlement to possession, custody and control. And can I just add in here that a point the learned friend made was to this effect, that there would not be a problem if the Vietnamese authorities were to intervene in the FWA's possession, custody or control of the aircraft. But we respectfully submit there would have been a problem, and it was known to be a problem, because of course it would entirely have the potential to frustrate our rights ultimately to export them, which is what was one of the main sticking points in the litigation at that time. I'm very happy to take the court through the historical sequence of the orders. I'm not sure whether that will really help. We've done a lot of pre-reading, as we're all gratefully note, and so therefore I was going to remind you to leave the sequencing unless you wanted me to, except for one point I'll take you to in just a second. But the allegation here is that VietJet took steps after the 14th of April order by Mr. Richard Salter, King's Counsel, sitting as a deputy judge, intentionally to procure third parties to do that which VietJet was itself specifically prohibited from doing under the terms of the prohibitory injunction, namely to interfere with FWA's right to possession, custody and control of the aircraft, specifically by inhibiting their export by FWA. Now, can I just pause here to deal with, as briefly as I might, VietJet's complaint that these grounds of contempt have been put in so many different ways, using different language, they cannot work out what is alleged. I'm shortening it and paraphrasing, but you know the complaint they make. I'm going to take this very shortly because we respectfully submit that there is really nothing in this, and it may be relevant when it comes to the disposition of this appeal, so I'm going to mention it. The knowledge and background and context that Mr. Justice Picken had by the time he delivered the judgment under appeal here, and a fortiori that VietJet had, should not be forgotten when considering VietJet's protestations of lack of clarity. Can I take you to Core Bundle, tab 6, page 71. Melania Friend took you to paragraph 18 in the course of his submissions, but I'd like to start the paragraph before. Beginning at line 3, I reject the submission in particular that there is a lack of proper particularization. When read as it were in the round, and by reference also to the third affidavit of Mr. Baker, dated the 13th of August 2024, and with a wider knowledge of the case that I have, as the judge who has presided over now 2 trials, and therefore necessarily the VietJet has, it is unreal for it to be suggested that there is a lack of understanding on the part of VietJet, the alleged contemnor, and for that matter the proposed second and third defendants, as to what it is that is alleged. That may be material when one comes to consider 2 of the points that are taken against us. 1, lack of legal certainty, I paraphrase, and 2, a lack of understanding as to what the allegations actually were, insofar as those are 2 separate points that are allied. It is our submission that the allegations were perfectly plain and completely understood by VietJet, and that there is no substance whatsoever in the criticisms that are made. Furthermore, it is perfectly clear upon what grounds VietJet will be tried. And of course that means, and these are matters for trial and not for now, that means the entire background that has led to this point, what was enshrined in the consent order of Mr Justice Bryan in November 2022, and all that has flowed from it since. I said I wouldn't trouble you with the background except for one point, and this is the one point. Can I take you please to the supplementary bundle, tab 11, page 89. And could I take you please to paragraph 8 in Mr Justice Foxton's judgment? I'm quite satisfied that the order preventing interference with control of the aircraft would include preventing interference with the exercise of the right to export the aircraft to Vietnam. If one has suggested to Mr Justice Waxman, in the light of his ruling, that it would remain open to the defendant to take steps to prevent FWA flying the aircraft out of Vietnam, I am fairly confident he would have been surprised. The order was not opposed at the return date before Mr Salter on the 14th of April. So one's got to keep an air of reality around these submissions, and while some of the points that are made by my learned friend and wrapped so attractively for the court's consumption are very beguiling, we must keep this appeal grounded in the actual facts of the case with which we are dealing. I repeat to the court against myself that we accept that these are matters, real matters for trial, but they are not for now. Can I turn, please, to the third heading, which is, what is the conduct of VietJet under scrutiny? Now, some of this we have covered already. I, of course, would not dream of wasting your time by covering it gratuitously a second time. And I'm also conscious of the fact that you've indicated more than once that you're fully au fait with the factual analysis, so taken as read. I won't trespass on the court's time, I hope, in my submission. You have in our skeleton argument, from paragraph 4 through to paragraph 12, pages 38 to 40 in the core bundle, what we say about the background. And as you know, this is but the latest, but I'm sorry to say by no means the last round in what is hard-fought, high-value litigation with no quarter given. I'd just like to emphasise, if I may be allowed to do so, these couple of points as regards the conduct under scrutiny, so that you have them clearly. At all times in this litigation, VietJet has emphasised, quite rightly, that it is a large international airline. It operates through a leadership team that is sophisticated and led by the second and third defendants, Madam Tao, who was then Chief Executive Officer, now Chair, and Dr. Phuong, then Managing Director, now CEO. It has had repeatedly and constantly advantage of representation of the highest quality in these proceedings, as that continues, as you know, today, with eminent and leading and junior counsel and leading law firms acting for them. So any suggestion that VietJet didn't understand any aspect of the litigation or was shy about asking for clarification is not advanced, sensibly not advanced, and couldn't be. Why does that matter? Because it matters if it comes to the point of a lack of understanding of anything so serious it goes to the root of our ability to be able to allow to amend, although we say that these are all really matters for trial later. Can I please just add two updates to the update that we already had through Learned Friends submissions? As you rightly pointed out, my lord, the appeal against the finding on liability was dismissed by this court on the 24th of June this year. The second trial took place between the 12th and the 22nd of January 2025. Judgment was handed down on the 17th of April, ordering VietJet to pay over $180 million in damages. And the Court of Appeal refused permission to appeal to VietJet on the 9th of July. third trial is listed before Mr Justice Picken to start on the 6th of March 2026. And these contempt proceedings, whether with or without 3A and 3B, will then follow on that as things are presently set. So that gives you the procedural context up to date. But when we're looking at this under the heading of what is the conduct under scrutiny and looking for a short way through all this that spares you a recitation of the facts, can I take you please to our skeleton argument, core bundle tab 3, page 42, paragraph 15. I think it can be reduced to these 5 short propositions.
Yes.
Perhaps I don't need to read them out, but you have them there on the page.
Thank you.
Thank you very much. Can I move now then, because I won't say anything else about the facts unless you would wish me to.
Thank you.
Thank you. To the fourth heading, which is, did the conduct constitute a criminal contempt? Of course, our submission is yes, and that the facts found reflecting the allegations made are perfectly sufficient to ground the new amendment sought and for which leave has been granted. This entire section of our submissions proceeds on the assumption that there are issues that are active and live for trial, but not relevant for today because of the way the court is invited to approach the issue. But it is, I think, here helpful or convenient to address VietJet's central thesis. VietJet argues that in criminal terms, the contempt alleged, which is an intentional interference with the administration of justice, by attempting to obtain the result prescribed by an order by means other than a direct violation of that order, is not known to law. As my learned friends say in their skeleton argument, paragraph 28c, there could in law be no contempt absent a breach. Our response to that is, as you know, extensively in our skeleton argument between paragraphs 37 and 50, but in short, what it comes down to is this. The appellant seeks the court's endorsement of a principle that an injunction respondent is free to act to undermine the state of affairs which the injunction seeks to maintain or create by encouraging or procuring third parties to take steps which it itself could not take without violating the injunction. Put differently, and as we observe at paragraph 30 of our skeleton argument, core bundle, tab 3, page 45, the principle which VietJet argues should be recognised is that an injunction respondent can never be liable in criminal contempt for conduct which is not expressly prohibited by the injunction, but nevertheless constitutes intentional interference with the state of affairs which that injunction seeks to maintain or create. That is, in our respectful submission, a breathtaking proposition when you think that what the consequences of it will be. But there is no support for this proposition that they've been able to show you, which is hardly surprising because we say it is contrary to both principle and authority.
Could not the terms of the injunction be drafted widely in a way which would capture all this activity?
Yes, in some cases that would be an answer. Yes, and I was going to come to precisely that in a moment.
When you say in some cases it could be an answer, so you'll presumably be directing our attention to circumstances in which it would not be an answer.
Yes, I'll do that now. No, may I come back to it, actually?
Please do.
But it's on my page to deal with.
Thank you.
And I will. And undoubtedly, my lord is right that in many instances you could. But we respectfully submit, just in headline form, that to do so would not work in all circumstances and may risk importing the uncertainty by the language being broad and permissive.
Well, do come back to that
in
your own time, Mr.
Thank you very much. Thank you. In response to that advanced central thesis of their case, we say in short form this. we submit the position is to the contrary. An injunction respondent that actively seeks the intervention of third parties with the intention that they take steps to undermine the state of affairs which the injunction seeks to maintain or create is manifestly interfering with the administration of justice, and so is liable in criminal contempt. And this form of liability flows from well-established principles of the law of contempt, and it is necessary in order to protect the powers of the court to determine the way in which justice is to be achieved in a particular case. Can I take you back, please, once more to Spycatcher, Authorities Bundle 1, Tab 8. In the speech of Lord Oliver, again, page 295 in the bundle, 217 in the report, at D. And if I could just invite you to remind yourself of how his lordship there put it.
Namely whether.
Correctly. Exactly so. By recognising that FWA's allegations that VietJet sought to procure third-party action intending that it have the effect of interfering with FWA's right to possession, custody and or control of the aircraft, could be held to constitute interference with the administration of justice, we submit, and the judgment under appeal did no more than apply well-established principles of contempt liability the particular circumstances of this case. All of the colourful descriptions as to the extent of the novelty of all this and the danger that it poses to the law of contempt and so forth, the learned friend peppered his submissions with so beguilingly don't actually rise. This is a much flatter answer than he would have. And ultimately, the question on this appeal is whether the injunction respondent who took the steps to bring about the intervention of the third party is outside the court's jurisdiction. Insofar as the BHP case is concerned, this has been a long journey in the preparation up a long cul-de-sac for absolutely no advantage whatsoever, I think, to either side, because I think we both in the end come to the position which we think is not relevant. But can I, just in case the court is, I'm misreading the position or the court is against me, can I just say this about BHP and Mariana? We rather doubt the court will want to get too deeply involved in the rights and wrongs of Mr Justice Constable's decision for three reasons. First, that will be for another division of this court in due course, as on the 9th of October, permission to appeal was granted by Lady Justice Andrews. Second, there is, taking it at its highest, no need in order to be able to resolve the issues in this appeal for this court to engage with that case at all. And third, even if you were to engage, and even if you were to overturn the ratio of the decision in BHP, which is, our respectful submission, highly unlikely, but if you were to, then that would still leave the overarching and, in our submission, trite principle of which it proves an illustration and no more. We only raised it in our skeleton argument, en passant, paragraph 44 and following. as being illustrative of wider general principles, not making any new principle whatsoever. And we're happy that it is forgotten. You will have seen that learned friends put in a long supplementary skeleton argument just on this case, arguing its irrelevance, and then if relevant, it's wrongly being decided. I'm in a position to deal with all of that material if you wish, but I'm rather hoping that you won't.
Another day, Mr. Lisa. We look forward to hearing you on that. Perhaps
I hope you're spared that. I hope I'm spared it too, but thank you very much. I'll leave it anyway. So picking this up then, where I'm moving towards the end of our submissions, I'd like to come back to a point that my Lord Justice Males put to me in the course of the submissions this morning, under the banner of, this is my banner, not yours, my Lord, forgive me, surprising results if the court were to grant this appeal. My Lord put to me, what would be the expectation of a third party? Would a third party who maybe knew of the terms of an injunction be expected to go and read the long supporting evidence, a judgment and so forth? And I said, no, of course not. I think it goes a little further than that. That it's cart and horse, in that for the purposes of our case, we are focused upon the horse and not the cart of the third party. And that there is a sequencing to the passage of information and action, which means that the exposure of a third party in what it does or doesn't know, has or hasn't read, doesn't appreciate, is ancillary to the role of VietJet before it. It's entirely possible that the party would not be aware of a relevant injunction or did not appreciate its meaning, as is likely in the case here. That should, in my submission, have no bearing on the liability of the injunction respondent seeking to use the third party as an innocent instrument, if it be such, to frustrate the purpose of the injunction. Were it otherwise, it is to put things, as I say, the wrong way round. In relation to litigation involving well-connected foreign litigants with which our courts are all too familiar, vindication for this appeal, VietJet succeeding in this appeal, would result in it being a clear roadmap for how to use their connections, should they wish to do so, to seek to undermine or take the sting from the orders of the court, intended to ensure that justice is done in the particular cases in which they are involved.
Can I just go back a moment?
Yes, of course, my lady.
If it had been possible to show that the letters had produced a result that was interference with export, then my understanding, I still have Lord Oliver's speech in front of me, my understanding was that that could be a civil contempt by VietJet on these facts, because it would have, on your case at least, interfered with export and therefore possession and control.
Yes.
So I'm just querying this is open season to get third parties, presumably outside the jurisdiction, to do things that the respondent is prohibited from doing. I'm not sure it is that straightforward, is it?
I've written on a sticky label here, caution with the floodgates argument, because they're usually the refuge of last resort, that if I lose it, open the floodgates. I understand exactly when a lady says it may not be quite that simple. And I'm not suggesting it would apply in a floodgate sense at all, but what I am saying is it would signal, wouldn't it, that in a variety of different factual matrices, some of which may involve the position you've just posited, where export is included and success is assured and therefore the link is made. A range of other situations in which that would not be the case, but which in each of them the common feature would be that the injunction respondent would be protected against criminal contempt.
We spent some time this morning on whether you could attempt to commit contempt, to which we were told the answer is no. So let's assume there was no third party involved in this case. And the respondent did something that maybe it wanted to interfere with possession or control, but it failed to achieve that objective. That wouldn't ordinarily be regarded as a contempt, would it?
If it's a singular instance where you have just the injunction respondent who wants to try to achieve something that would be a breach but fails to do it, as it were, this is the hypothesis. No, that wouldn't be a contempt by him, no.
So why is it different with the third party here?
Well, the difference here is because what happened was that the injunction respondent, I've been careful how I put it, but knowing what they were doing, let's put it that way, having conscious of the terms upon the prohibition upon them, tried to get an arm's length third party, i.e. parts of the government agencies of Vietnam, to take steps that would have the same end result without their fingerprints on it. So they write a letter or letters to say the Department of Transport or the Deputy Prime Minister, termed in the way in which Mr Justice Picken described them in his judgment in that passage you looked at in 380 and 388 earlier on today. Knowing perfectly well what they're doing, knowing that what they want to try to achieve is something which they cannot achieve directly. That is different, and it doesn't succeed. That is totally different because it has two elements to it that are lacking in the first example that my lady gave me with respect. The first element is it has an actus reus in the writing of the letters and sending them. Secondly, it has a mens rea in the intention behind them, the purpose of what they were trying to achieve.
I'm going to sound like a cracked record, which I apologise, but I'm still not clear how whether you're going to show us that there are circumstances which could not be covered by a properly worded injunction.
Yes.
I mean, some injunctions in other areas of the law included injunctions against attempting to enter a property.
Yes.
For example.
It's the very next point in my note.
I'm so sorry.
It's a relief we've got there. I'm sorry to have kept you waiting.
No, of course not.
As my note says, it could be said that this situation could be guarded against by more expansive drafting of the prohibitions in the order itself.
Yeah.
And in certain cases and circumstances, that may indeed be possible. However, seeking to prohibit on the face of an order conduct which may have the effect of causing a third party to engage in such a way as would violate a provision of the order if engaged in by the injunction respondent, in many cases risks raising the questions of legal certainty which VietJet complain of today. For example, liability for civil contempt only requires it is established that the conduct in question was engaged in knowingly and that the injunction respondent was aware of the injunction. Without the requirement of showing an intention that the third party engage in the conduct prescribed, as is necessary to establish the principles of criminal contempt, the liability of the injunction respondent would arguably be impermissibly uncertain, perhaps particularly so in the corporate context. And that's the problem, that whilst one can in the abstract frame, in many cases, as I freely concede, that you could guard against what the situation we have here by more expansive wording. The wider one casts it, the greater the risk for imprecision or uncertainty. So taking active steps intentionally to try to circumvent a civil order is, in our submission, quite properly the domain of criminal contempt. There's no need to indulge in greater expansive drafting of injunctions with the risks that that imports. Because this is bog standard stuff, if I may put it in that clumsy way, for criminal contempt. It is, in our submission, inherently contumacious conduct, which deserves to be labelled as criminal contempt to do what was done in this case. And you have the unusual position, in this case, of not having to rely upon allegations made by counsel or in evidence or anything controversial. You have findings by the commercial court, which are informed by having dealt extensively with the VietJet FWA litigation in the shape of Mr Justice Picken, expressing his views quite clearly as to what the purpose and intent was, he having conducted the trial. And whilst, as my Lord Justice Mills pointed out, he didn't say, and that equals a contempt of court, but with respect, he wouldn't do, because he wasn't dealing with that issue at the time anyway. He may be yet in next March or thereafter, but we'll see. But there's no need to worry about, could this all be dealt with by way of amendment, the language, or broadening of the language, or more creative drafting of the language in the order itself, with all the risks of imprecision and so forth that imports. When in fact it's extremely simple. You've got the order, you've got the purpose of you've got the actus reus, and you've got the mens rea, you've got a criminal contempt. VietJet's objection that the conduct complained of does not involve a violation of the order itself misunderstands the basis for the court's jurisdiction in our submission. And perhaps for the last time, can I just remind you of two passages from Lord Oliver's speech in Spycatcher, if you'll forgive me. Back to tab 8. On page 299. I invite you, please, just to remind yourself of the passage at the foot of page 221 in the top, 22299 in the bottom at H. My lords, there can be no logical distinction. I invite you just to read that and over the page, please. And then at the bottom of page 302, page 224 of the report. I invite you please to read from H there to the top of the next page.
I'm sorry, I was just reading, I was still reading the first reference. Trying to
so
work out
sorry.
exactly. The trouble with dipping in and out, of course, is that one has to find one's way in again. So, yes, the second reference.
It's page 302 in the bundle reference.
Yes.
Page 224.
Yeah.
At the very bottom of the page. Once it is accepted, it seems to me, the authorities compel that contempt, to use Lord Russell of Cologne's words, need not involve disobedience to an order binding upon the alleged contemner. The potential effect of the order contra mundum is an inevitable consequence. Indeed, if were it not so, the administration of justice, which is the purpose of the law of contempt, to uphold, would be largely deprived of any effective protection.
But the context here, unless I've forgotten, is that an argument that the other newspapers couldn't be liable in couldn't be treated as being in contempt because it was the respondents who were named on the respondent newspapers who
Yes.
were named in the order. That's the context.
It is.
So what, as I understand it, the Lordships was saying was what the order is getting at is prohibiting publication. And the fact that the order on its terms named particular newspapers doesn't mean that other newspapers cannot be responsible in criminal contempt if they do the thing, publication, that is prohibited by the order, even though they are not named in the order.
Yes, that's right.
That's right. Not exactly the same as what you're seeking to establish now.
No, it's not, and I'm not trying to overfreight it with a greater weight than it can properly bear as a point made. It's one of my last points for a reason. But we respectfully derive from the generality of what His Lordship there says, in the context, accepting what my Lord Justice Baker said, dipping in and out from the totality of the judgment, which both sides have treated as being golden in the context of this hearing. We've all been taking bits out of it, left, right and centre, rather than letting anyone read it as a whole. My lady's obviously right. There's a limit to how far it runs. But the generality of the point still stands in our submission. It's a very helpful encapsulation of consequence. And Lord Oliver's speech in this regard was relied upon by the Supreme Court in Wolverhampton. You've looked at paragraph 37 already. Just for your note, you might glance later at paragraphs 38 and 39 as well, but I'm not going to trouble you to go back there now. For your reference again, it's Authorities Bundle, Bundle 2, tab 35, page 1033, but no need to go to it. And taking all that my lady has just said, and underlining it, we submit that the same thinking must pertain in relation to actions taken by the injunction respondent intentionally to bring about the frustration of an order. Which brings me to our conclusion, subject to the one point I had to come back on, which I will in just a second. We say that the learned judge here made no error of law in allowing the two grounds of contempt which he permitted the respondent to advance by amendment to run. They disclose reasonable grounds for bringing the application and have a real prospect of success. There is no warrant for the proposition that where it was not alleged that the appellant had breached the injunction, it was not open to the respondent to pursue contempt proceedings on the basis the appellant had taken steps intentionally to circumvent it, and the alleged basis that the appellant had sought to interfere with the administration of justice by attempting to circumvent or undermine the injunction, perfectly sound in law and at this stage on the facts. And may I just turn around a second? Thank you very much indeed. May I just read this? Sorry.
My lord has a question.
Yes, I thought you were about to say something else, Mr.
I was, at your convenience. I was going to come back to the question on Supermax.
All right, well, you deal with that, then I'll ask my question.
Thank you very much indeed. Can I take you back, please, to Supermax again? I made a mistake, I think, is the short point. Supermax, which is Authorities Bundle 2, tab 31. I come to page 905. My lady put to me that the authority didn't involve the circumvention of an order, which is a proposition that I agreed with. I was wrong to agree, so I'm sorry.
Yes, I think there was murmuring on the other side to that effect, which I overheard. So
Well, they were
maybe
right.
pushing at an open door. Do you want just to underline the point for us?
Yes, of course.
On
It
that
did
one.
involve the circumvention of an order. Paragraph 107, which I took you to earlier on page 905.
Yeah.
If I could invite you, please, to within that long sub-paragraph, read the grounds of contempt,
Yeah.
11 and 12. Which are
Sorry.
lengthy.
11
Sorry,
and
well,
12.
I think I'm in the
And
wrong
stop
place.
at 9.
Now, they begin at 11 at the foot of.
Oh, I see.
It's rather misleading. You would think it might start at 1, but it starts at 11.
Oh,
And then 12 is on the next page. And it's clear from that the so-called Baker order, as it's referred to, included a prohibition against the respondent from removing relevant employees. That was the order.
So there was an order. Thank you.
The allegation was that by procuring these criminal proceedings, etc., you see the point.
Yeah.
And whilst there was an element of preventing them from giving evidence, that was the sole basis. Reference to the Baker order would have been redundant. So we know that interfering with the witnesses was a freestanding criminal contempt.
Thank you.
That's what I was going to say. Now, my lord, you have
Yes.
a question.
Well, only this, that Mr Malik submitted that the judge, in his judgment, did not actually grapple with the point that arises on this appeal. I just wondered whether you agree with that, or if you don't agree with it, can you point us to the paragraph where he did?
Well, my lord, I sure knows that I can't point you to a paragraph where he did,
Okay.
because I don't think he did.
Well, I agree. I just wanted to make sure I hadn't missed something.
No, you
Or
haven't. No, never, and certainly not on this occasion. No, you haven't missed anything. Where that then takes us is of course, a separate matter which you're not asking me to espouse upon. But he didn't deal with it. Whether it was necessary to deal with is a matter my lords will determine.
Thank you.
Is there anything else I can?
No, thank you very much, Mr. Lizette.
Thank you very much.
Now, Mr. Malik.
We'll
Can I just check how long are you going to be? I asked
10 minutes?
5,
10 minutes?
I hope the stenographers will be content.
Thank you.
Thank you.
First point, it's important for the court to characterise the issue before it. And in my submission, the issue of characterisation is about the meaning of a court order. And that, in my respectful submission, is a matter that is dealt with comprehensively by the law of civil contempt, where there are a whole series of protections, rules, and everybody knows where they are in terms of certainty and fairness. There's been discussion in terms of whether the result may have been different had a contempt taken place, but we don't have to deal with that. There's no application to put the case on a different basis. The court, in our submission, has to deal with it on the basis of the claim as formulated. There are rules, CPR 81, about the importance of following what is alleged in relation to the notice. And these parties, rightly or wrongly, have accepted that there is no breach of an injunction by my client. Now, of course, we could all think of ways that a breach might have been alleged, but that's not the exercise that the court is being involved in. So, for example, if we look at the order that the Deputy Judge made at Supplemental Bundle 179, you may have noticed that it says, until further order, the defendant is prohibited from 1, taking steps to re-register, and 2, taking steps. Now, had the words taking possession and going on to talk about otherwise interfering. Now, if the words taking steps had been moved, it might have been different. It might have been different. You could have covered exports, but that is not
included by themselves or by encouraging,
exactly
etc.
all those kind of things. And so my submission is that there is nothing surprising or unjust. There's no lacuna. The law of civil contempt is clear. And in my respectful submission, they have elected not to go down that route. In my submission, they were right to go down that route. But what they can't do is to say, well, there's an injustice, there's a lacuna. If there is an injustice or a lacuna, that is simply because of the way they decided to formulate their case. And then when one says, well, no, it's okay, we're not alleging a civil contempt, we're actually arguing the more serious offence of criminal contempt, The notion that there can be a criminal contempt in relation to a court order where it is accepted that there is no breach just has to be stated to make it clear that it can't be right. And we've seen from the authorities, whether it's Wolverhampton, whether it's Lord Oliver, they're all consistent in terms of the need for a prohibited act. A prohibited act is a breach of an order, and that is not being alleged here. So, in our submission, with the greatest respect, the position accepted by both parties is that the judge did not grapple with the issues in the case. He made a fundamental error of legal principle in saying that one could look to the intention, the essence, in order to find a criminal contempt. And in my respectful submission, he is clearly wrong. The two other points I just wanted to make briefly was on the Malhotra case. The court can obviously look at it itself, but it's got no relevance at all. It's not dealing with the case before this court. It's essentially dealing with intimidation of witnesses. And when my learned friends cite that case to support their proposition, the reality is that there is no authority to support the proposition that there can be a criminal contempt in the context of court orders where it is not alleged that there is a breach or a prohibited act. And as I've said, it's not only the fact that there is no authority to support it, everything goes the other way for reasons that I elaborated this morning. The only other point I wanted to make briefly was on the relation to the municipal case, the BHP case. The reason we spent so much ink on the BHP case is because it was presented to us as the answer to the case. And you've seen it from this skeleton where they say that this decision of Mr Justice Constable supports their proposition. It doesn't support their case. It's not dealing with this case at all. And that appears to be common ground. So I don't need to say anything more about it. Those are my submissions.
Well, thank you very much, Mr Malik, Mr Lissack, and to other counsel, and to those sitting behind you, and to those sitting immediately in front of me for their hard work and assistance on this case. We're going to reserve our judgments, you won't be surprised to hear. In due course, we will be sending out a draft judgment in the usual way for you to correct any typographical or minor factual errors, obviously not to re-argue the case. Please bear in mind the rubric at the top of the order, which warns you that it is a contempt of court for that draft judgment to be published. And there's no doubt about what contempt means in that context.
It covers attempts as well.
It covers attempts as well. Well, thank you for clarifying. I hope we won't have to deal with that on either base, on any basis. In due course, we'll of course hand down a final version. No need for attendance on that occasion. Please would you draft an order that reflects our decision when you see our draft judgment, yes. Insofar as there are any differences between you on any ancillary issues, we will deal with those differences in writing. We'd be grateful for short written submissions on those various issues.
Certainly.
Thank you very much.
Thank you very much indeed.
Court rise, able